Muy buenos días a todos ustedes. En nombre de la International Chamber of Commerce México y la Universidad Autónoma de Querétaro, les damos la más cordial bienvenida a la conferencia de inicio de semestre 2020-2 de la Facultad de Contaduría y Administración de esta universidad, que organizamos en coordinación con el Comité de Arbitraje Bajío. Les recordamos que nuestras reuniones se rigen bajo el protocolo de competencia económica que se encuentra integrada en la convocatoria a esta reunión. Con respecto a esta conferencia, les recuerdo que tenemos algunas recomendaciones, por lo que les pedimos, por favor, mantener siempre su micrófono en silencio. Al finalizar las exposiciones, tendremos oportunidad de recibir sus preguntas, para lo cual les pedimos, por favor, levantar la mano en su aplicación o solicitar el uso de la voz en el chat de la plataforma. Sin más, damos inicio a nuestra conferencia, para lo cual le cedo la palabra al maestro Guillermo Aldana Ugarte, presidente del Comité de Arbitraje Bajío de la International Chamber of Commerce México. Muchas gracias. Adelante, maestro.
Muy buenos días a todos, muy buenos días a los expositores, a los integrantes del Comité de Arbitraje Bajío de la International Chamber of Commerce. Les damos la más cordial bienvenida a una más de nuestras actividades académicas que lleva a cabo el Comité de Arbitraje Bajío de la ICC, que en adelante y al menos hasta que termine este año serán en formato virtual. Este formato permite contar con expositores e instituciones extranjeras de gran prestigio mundial, como los que nos acompañan el día de hoy: la Universidad de Lund en Suecia y uno de sus académicos más renombrado, el doctor So-Yun Lee. En esta ocasión tenemos también el honor de contar con la presencia de la licenciada Diana Cuevas, un doble honor, pues es además integrante de nuestro Comité de Arbitraje Bajío. Ella es vicepresidenta de este comité. El Comité de Arbitraje Bajío de la International Chamber of Commerce, que me honro en presidir, se encarga de desarrollar el conocimiento y práctica de los diferentes mecanismos alternativos de solución de controversia, también llamados en inglés ADRs. En nuestro país, desde hace algunos años, la mediación ha sido objeto de diversas regulaciones, principalmente a nivel estatal y dentro de la estructura de los poderes judiciales de los estados, quienes han desarrollado centros de justicia alternativa y legislaciones locales que tratan de regular la mediación y los convenios que surgen de este proceso. En este escenario ya se había aprobado una ley general de mecanismos alternativos aquí en nuestro país, que incluía una reforma al Código de Comercio y que fue dejada de lado por otra iniciativa que actualmente se está discutiendo y que se pretende enriquecer con la participación de los expertos del foro. Pero la pregunta que frecuentemente nos hacen en este tipo de instituciones es: ¿qué sucede con la mediación internacional? ¿Cuál es el proceso? ¿Quiénes intervienen? ¿Cuál es el marco jurídico? Y sobre todo, ¿cuál es su aportación al entorno mundial? Es innegable en este contexto hablar de la Convención de Singapur sobre mediación internacional, que justo fue celebrada hace un año y que pretende dar certeza a los países que forman parte de dicha convención, temas que serán abordados el día de hoy por nuestros conferencistas. En cuanto a la mecánica de participación de nuestros expositores, y dado que el día de hoy contamos con un expositor que se conecta desde Suecia, su intervención será en inglés y por lo tanto esta sesión será conducida en ese idioma. Con la idea de no interrumpir las dos intervenciones, abriremos un espacio de preguntas al concluir las mismas. Antes que nada, quisiera darle la palabra a la maestra en Administración, Mónica López Arellano, quien es coordinadora de la Licenciatura de Negocios y Comercio Internacional de la Universidad Autónoma de Querétaro, quien en representación de esta casa de estudios nos dará un breve mensaje. Y pues dado que contamos con un expositor internacional, me parece que estaba a punto de conectarse. Si ya lo hizo, pudiera hacer el mensaje en inglés. Si no lo ha hecho aún, bueno, podría darnos el mensaje en español. Muchas gracias de antemano, Mónica, por tu, digamos, empeño, tu voluntad y siempre tu nivel de participación con nuestro comité. Y gracias de nuevo por la coordinación de este evento. Te cedemos la palabra, por favor, Mónica.
Good morning, everybody, and thank you especially to Dr. Soyu Lin from Lund University. Thank you. It is a truly honor to have you here in collaboration with ICC, the International Chamber of Commerce. For us, it is really important to have such as a high-level keynote speaker as you, as Diana Cuevas, Samuel Villazón, and Guillermo Aldana. Please feel free to share your expertise with us, and we are really happy to have you here at the University, Autonomous University of Querétaro, and its Faculty of International Trade and Business Bachelor's Degree Program. Thank you all.
Thank you very much, Monica. And I'd like to welcome our first speaker. She's Diana Cuevas. We are very, very proud since she represents our ICC Arbitration Committee for Bajío as Vice President. Before her participation, I just want to introduce her to the audience. Ms. Cuevas has more than 20 years experience working as international corporate attorney and has particular experience in the technology transfer, real estate, mediation, and contract negotiation mediation sectors. She has been part of several international firms in Boston, New York, and Mexico, has also worked as mediation officer for the U.S. Federal Court, District of Massachusetts, USA, since 2005, when she founded Mexico Real Estate Group. She has led several projects representing companies such as Kimco International Living, Inc., and Richard Ellis Investors. Prior to this, she served as in-house counsel and vice president for Pure Imaging, Inc. in Massachusetts, USA. The legal transaction in which Ms. Cuevas has been engaged have involved issuers in Europe, United States, Mexico, and China, leading renewable energy, oil and gas like Iberdrola, Vestas, and TransCanada, as well as commercial development projects amounting over $590,000 million, and serves as business consultant for state governments. Ms. Cuevas specializes in international mediation, contract law, and international law. She advises on corporate transactions, civil matters, government affairs, and regularly acts for founders and those investing in early stage and startup ventures. She also serves companies in chief negotiator and mediator on a wide range of contractual arrangements, including outsourcing to other jurisdictions globally. Ms. Cuevas is currently VP of the International Chamber of Commerce Arbitration and Mediation Committee, Chapter Bajío, attorney of counsel for Alaris Law Firm in Paris, France, managing attorney of DC International Law in New York, and partner of Ibanez Parkman Law Firm in Mexico City. In education, Harvard University Law School, Master Degree Mediation and Dispute Resolution, Suffolk University, Boston, LLM Technology Transfer Law in Lund University, student, LLM European Law and LLM International Law in Instituto de Estudios Superiores de Occidente en 1999. She has several certifications, among others, American Association of Mediators, American Society of International Law, ICC, BP Arbitration and Mediation Committee, and the National Association of Corporate Attorney Mexico, International Bar Association. Thank you, Diana, again for your time to organize this conference. Please, you have the floor.
Thank you very much, Guillermo, and thank you very much, Monica and Laura, for having me. It's a true pleasure and an honor also to be here with you. I'm going to, as you said, give a brief of what international mediation is. I'm going to try to make it brief so we have enough time for Q&As at the end and give enough time to Dr. Lee to give his presentation. It's going to be very general, and I hope it's enough information. If you have obviously more questions, then you can refer to them at the end. So I'm going to share my screen, and I was telling my co-host that this is the first time I share the screen, so bear with me. I'm going to try to do this as quick as possible. We're going to start by touching the very basics of mediation and international mediation. Mediators help people to identify their own needs, clarify issues, expose situations, and negotiate their own agreement. Mediators do not advise those in a dispute. Mediators are not counselors, but help people to communicate with each other. Mediators are impartial and must have no stake in the outcome of the process, because a mediation is a flexible and consensual technique in which a neutral person helps parties reach a negotiated settlement of their dispute. The parties have control over the decision to settle and the terms of the agreement. Settlements are contractually binding and enforceable. Mediation is a useful approach when parties in a dispute have an ongoing relationship that they wish to keep, such a joint venture or long-term supply contract. With mediation, this is possible, whereas there is likely to be any legal basis for seeking such relief in arbitration or litigation. The United Nations Convention and International Settlement Agreements adopted the now known as Singapore Mediation Convention, or the Convention, originally adopted by the United Nations General Assembly in 2018, which applies to settlement agreements resulting from mediation and international disputes. The Convention's goal is to promote mediation as a viable alternative to litigation of international trade disputes by creating an effective process for enforcing a resulting settlement agreement. There is no doubt that the mediation across border disputes is going to gain traction as a viable alternative. Enforcement of agreements is the key. At present, enforcement of a settlement agreement through a predetermined dispute resolution process is straightforward when the parties and the enforcement process are in the same jurisdiction. However, for parties that have agreed to settle internationally, court proceedings in one jurisdiction to be enforced in another jurisdiction, it's going to be a little tricky. We will apply domestic law in the country where the settlement is going to be enforced. However, signatories of the Singapore Convention will actually apply laws and regulations of the Singapore Convention as a guide to the applicability of the law. The problem led to the creation of other models as the on-site control of the United Nations and institutional guides, like, for example, the International Chamber of Commerce, that we use as I said, guides to the applicability and enforceability of settlement agreements. In other words, enforcement is left to the jurisdiction where the parties choose to enforce the settlement agreement. So when we think about international mediation, what is the most important thing that we have to consider? Clearly, we have to consider the option of harmonizing laws from each state or country so we can actually apply and make sure that we can enforce international mediation and our settlement dispute. In my opinion, is that international mediation is more a step towards establishing a diversified range of dispute resolution options for parties to international disputes. So, is it fair to say that it's still premature to consider whether the convention will be universally adopted, and if it is, will it encourage parties to resolve cross-border disputes by means of mediation, since it was introduced to provide a harmonized framework for international settlement agreements arising from mediation? It does directly address the main problem of mediation as a dispute resolution forum, which is the lack of enforceability of settlements, recognizing these as binding and enforceable while still remaining flexible and efficient in a mediation process. However, mediation can be a useful tool for conflict resolution, as the confidential and non-adversarial process helps preserve commercial relationships that may otherwise break down if alternative litigation or arbitration routes were taken. Undergoing mediation can potentially enable business individuals to mitigate their losses and strengthen the long-standing relationships that we want. There are three types of dispute resolution methods. There's mediation, there's arbitration, and there's a med-arb hybrid, or med-arb-med. We can start with mediation, but if the parties do not reach a settlement, then we can shift to arbitration. Sometimes we can start with mediation, shift to arbitration, and then come back to mediation. And we can talk more about that if you have questions at the end. Advantages of international mediation or mediation per se is the process, irrespective of the expression used or the basis upon which the process is carried out, where our parties attempt to reach an amicable settlement of their dispute with the assistance of a third party, lacking the authority, this third party, to impose a solution upon the parties to the dispute. An agreement has to be in writing between the two international parties, and which is also signed by the mediator. That qualifies for enforcement in the courts of a ratifying member state of the Singapore Convention. Grounds for objection to the enforcement are provided in Article 5 of the Convention, which are very similar of those actually of the New York Convention. The Singapore Convention could encourage sequel dispute resolution agreements, including binding mediation as a first step, with the parties only available to proceed to arbitration or litigation should mediation fail. The reasons why we like mediation so much is because holds in hand privacy, the privacy of the parties. They do not have to go to court. They can just be in a single room or in different rooms and have the negotiation taking place. Confidentiality. Whatever settlement they have reached is going to be confidential to everyone around them. The exclusion of liability. The exclusion of liability is very important because the mediator is not going to be liable. Is going to be accountable, which is different, but not liable. He is just there to assess and test that a mediation has been taken place and a settlement has been reached. Here is very important to take in consideration the job of the international mediator, which is going to be responsible for the interpretation of the law and the application of the law, which typically is going to be the jurisdiction, meaning the country where it's going to be enforced, and the enforcement, whether the parties have decided to call the Singapore Convention or just domestic law. Previous concerns about the enforceability of mediated settlement agreements are slowly being put at rest, as mediated settlement agreements can now be immediately converted into an enforceable consent court order with the Singapore Convention on Mediation due to come in force in September of this year. Commercial parties in international disputes will soon be able to seek enforcement overseas by applying directly to the courts of countries that have signed and ratified the treaty. The problem is, I think, that currently the convention is more aspirational than operational, given its exclusions and exceptions, and it has only been ratified by a few countries. Nevertheless, it will become in force, as I said, in September of 2020. Although major players such as China and USA as signatories have not yet ratified. At the moment, neither UK or any European countries has signed. That might be because of the reliance on the EU Directive on Mediation. At present, enforcement of a settlement agreement through a predetermined dispute resolution process is straightforward while in the same jurisdiction. As I said, however, it is more complex for international settlement agreements. For instance, if the parties may have agreed to court proceedings in one jurisdiction to enforce the terms of a settlement agreement, but the court's judgment may then need to be enforced in another jurisdiction, assuming enforcement is permitted in a foreign judgment. The convention specifically provides that it shall not prevail over conflicting rules of a regional economic integration organization. So the enforcement of agreements will be subject to any additional preconditions imposed by regional organizations, such as obtaining the counterparty's consent. Significantly, the convention even permits states to make two prescribed reservations at the time they ratify, and I will talk about that in the next slide. So, the contracted state may declare, 1, it will not apply the convention to settlement agreements to which the state or the country is a party, and the state may further extend this reservation to settlement agreements entered into by government agencies or agents of government agencies. And 2, the convention will only apply to the extent that the parties to the settlement agreement have agreed to the application of the convention. Effectively, a state can ratify and at the same time opt out. Moreover, while the convention is intended to cover mediated disputes, the convention defines mediation as a process, irrespective of the expression used or the basis upon which the process is carried out, whereby the parties attempt to settle. What do I mean with this? So I can sign the convention and ratify, yet at the moment that I enter into a settlement agreement, which is going to be in writing, it's going to be like a contract, I can actually opt out of applying the convention. So the settlement agreement is going to be enforceable, but I'm not going to apply the requirements and applicability per se of the convention. While some requirements may vary from jurisdiction to jurisdiction, if we focus on the Singapore Convention as a harmonizing document, the requirements to enforce a mediated settlement agreement must be in writing, signed by the parties, and certified or signed by the mediator. While this seems simple enough, not only does this last provision create some issues, but numerous exceptions and carve-outs that follow these simple requirements further dilute the impact of the convention. The convention specifically excludes from coverage the following agreements as well. Those relating to consumer transactions, family inheritance, or employment law. When I'm talking about, remember, the Singapore Convention, not all mediations exclude this. So, as some critics of the convention note, by excluding family-related settlements, disputes involving a family-owned business may be excluded. And I'm talking about, and I'm focusing, as I said, in the Singapore Convention, because it's the document to go to if we're dealing with international mediation. Additionally, exclusions include settlement agreements enforceable as judgments or as arbitral awards. This exclusion is intended to avoid an overlap with other governing rules, such as the New York Convention, the Convention on Choice of Court Agreements, and the Convention on the Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matters. Here are some tips for a successful mediation. When you deal with parties from across the world, you will face some challenges, such as language barrier, time managing, and cultural norms. So be aware of the rules of engagement for international mediation. Do some research on the other party's culture. Consider the individual. If rule number one in international negotiation is to know the other side's culture, rule number two then is to avoid over-reliance on that knowledge. Build bridges across culture. Don't get frustrated. Consider the broader context. By seeing the negotiation through a wider lens, you can incorporate critical concerns and increase your odds of reaching a successful and long-lasting agreement. Take steps to reduce stress. So avoid an impasse in a conflict by taking some deep breaths and trying to understand the other party's interest and frustrations. Try to find a common area where you can talk and you can reach an amicable agreement. Mediation as the new normal. Look, we've all been taken out of our comfort zones and regular ways of doing things. Although mediation has been available for a long time, it is still fairly new in terms of international dispute resolution. Unfortunately, this pandemic has disrupted business and social environments in ways we could have never imagined. We can expect dispute resolutions to become the new normal in many cases, in both in its online and offline forms. It seems we have fast forwarded at least 5 years in terms of the market willingness to settle agreements online. You know, once parties discover the convenience of it, they will likely to continue to make use of it, even after international travel has opened again. I am sure we all agree with that. Now, the Singapore International Mediation Center has launched the protocol for COVID-19 to provide an expedited route to resolving international disputes during the pandemic. So if one realized that it's actually possible to be more effective and efficient, it is likely to continue like that in the future. Why do I think so? Well, since the economic impact of COVID-19 on businesses and commercial parties can be felt across the world, like unfulfilled contractual obligations, supply chains and logistics, cash flow, employment issues, we have no other option but to look for better and faster answers to our disputes by digital means, which has been now very popular. To do this, we have to embrace the new remote communication technologies and be more open-minded as to negotiating to reach an agreement and not to just win, but to actually share the blame with the other party and share the gain as well. In other words, to be more effective and flexible regarding business in the new normal. So once we master the art of international mediation, we won't have to see a court day again. I thank you very much, everybody, for taking the time to listen to me.
Thank you, Diana, again, for your participation. Definitely, it's a very interesting topic based on the signature of the Singapore Convention last year. It is very actual and for sure will be subject to many changes in the future. We are also very happy and honored today for having a very important speaker from the University of Lund. Due to his vast experience in the field, he's an authority in this matter. But before giving the voice to our speaker, I would like to introduce him to all of you. Mr. Soyu Lee is a UN 2030 Agenda Program PhD researcher at the Faculty of Law in Lund University, where he works on matters of international trade and investment law and dispute, as well as in interdisciplinary approaches involving development, economics, and law and development, LD. Prior, he was an international law and dispute settlement associate at the Asan Institute for Policy Studies in Seoul, South Korea, specializing on issues of international economic law, specifically international trade and investment law. Before joining the Asan Institute in 2015, he worked with the UN Office of Legal Affairs International Trade Law Division, providing substantive and technical contributions to the UN Commission on International Trade Law, UNCITRAL. He was also a research fellow at the Columbia Center of Sustainable Investment at Columbia University Faculty of Law, and is currently a fellow for the Asian Institute for Alternative Dispute Resolution. He founded and operates a firm that provides legal and advisory services to Korean corporations on matters of economic, policy, and legal trends around the world. He pursued his own undergraduate education at the New York University, Bucknell University in US, and his postgraduate education at the United Nations University, University of Tokyo, Cambridge University, and the in Hawks Hall, and the Massachusetts Institute of Technology. Research interests involve the nexus between international economic law, dispute settlements, sustainable development, structural and development economics. I just want to highlight some of his doctoral project. The objective of the project is to understand a state right to regulate in international economic law, specifically international investment law, through the use of policy measures meant to advance sustainable development. In doing so, the project identifies the substantive and procedural meaning of sustainable development in international economic law and compares it to the way that sustainable development policy is defined and assessed by the United Nations with the UN 2030 Agenda and its core. Dr. Lee, of course, has many publications. I will just mention some of them. In 2020, Fair and Equitable Treatment in International Investment Regime of the Democratic People's Republic of Korea. Soyun Lee, 2020, accepted in press in Chinese-Taiwan Yearbook of International Law and Affairs, Contribution to Journal, Article 2019, in the Habit of Giants, Fair and Equitable Treatment and Structural Risk Factors in Conglomerate and Newly Industrialized Countries. He has publications in 2018, in 2017, 16. He has substantive publications. Thank you again, Dr. Lee, for sharing your experience. It was a very, we are very honored to have you here. And please, you have the voice.
Thank you for that very generous introduction, and I'm very happy to be here to talk about this subject. I'm just going to share my screen. I'm going to assume that you can hear my voice. Okay, so are we able to see my screen? Okay, good, excellent. Yes. So I'm just going to skip the introduction because that was such very kindly done for me. So today I'll be continuing off Diana's presentation by talking about some of the controversies in international investment arbitration. And we saw in Diana's presentation that sort of mediation is obviously an ideal outcome for the settlement of a dispute because it's non-hostile and it saves both time and money. But of course, many times arbitration will continue to arbitration largely because, as Diana said, mediation is yet in many jurisdictions not having legal effect in terms of the outcome. That being said, so today I'll be talking to you about a few of the controversies of investment arbitration as one example of some of the controversies of arbitration in general. So I'm just going to see if I can. Okay. So first, let's take a moment to place this lecture within kind of today's theme. So why international arbitration? So before that, like I said earlier, everything I'm going to talk about today is highly debated in international law. And that being said, one of the main benefits of international arbitration is that they are third party. So what that means is that they often involve institutions like the London Court of International Arbitration, LCIA, or the World Bank's International Center for Settlement of Investment Disputes, ICSID. And since they're third party, the idea is that they will be free from the influences of national political influence, right? So if you're an investor and you're investing in a foreign country, or not even investment, but any form of arbitration, you have to rely on national court systems. And as a foreigner, you might have some doubts in terms of the neutrality and objectivity of those processes. And this is where arbitration comes in. And so arbitration provides a kind of a third party or more of an independent, but of course that's debated, form of dispute settlement. And of course, the idea of an independent judiciary is not, there are no few examples for this because we can see this happening all over the world, especially amidst kind of very geopolitical situations. And so another benefit of international arbitration is that it is less litigious. And what that means is it's less hostile than litigation. So when you enter into a domestic litigation, it can get very hostile very quickly because it involves tort, it can involve other processes of enforcement. But arbitration is helpful because it can preserve business relationships. And obviously that's very important, especially if it comes to things like construction or infrastructure development, where if you have a very hostile legal dispute, it can end the business relationship entirely and you can have construction projects that are left undone. And this can obviously cause not only environmental damage, but also waste of public finance. So another benefit of arbitration is that arguably, I'm not sure if this applies anymore, arbitration was supposed to be a more affordable means of dispute settlement. And that's because that the costs and the arbitral award, how much compensation the investor or the winning party receives, is oftentimes going to be also deliberated by the arbitration tribunal, and this is called quantum, right? This is a whole other area that's also very contentious, especially now because we have things like AI quantum, which is becoming quite debated all around the world. That being said, the third benefit is that international arbitration is more adaptable to technical fields such as construction, infrastructure, and energy projects, especially cross-border energy products. So a unique aspect of arbitration is that it provides an option for what's called expert adjudication, which permits a technical expert, so it can be a construction expert, an energy expert, or anyone in the related field, to first attempt to mediate the dispute based on the technical merits. So for example, if it's like a construction dispute, it can be a matter of finding out whose data is more correct, for instance. And this can be a useful way to resolve a dispute before it gets to arbitration, and where they begin to discuss sort of the legal aspects of the dispute. Now, in the interest of time, I have to kind of, there's obviously several more benefits of arbitration, some of which that Diane had gone through, but in the interest of time, I'm just going to kind of group the last few benefits into one big statement, which is that one of the biggest, perhaps one of the most valuable contributions of arbitration is that it opens up a dispute to the principles of international and customary law. Now, this includes, for example, there are some jurisdictions that require mediation, mandatory mediation before arbitration, and the mediation has legal standing. And we can see this in Malaysia, for example, where this takes place. Another possibility is, for example, requiring the exhaustion of domestic remedies. So instead of going straight into an international court and kind of jumping over the domestic court system as an international investor, for example, exhaustion of domestic remedies can first require you to go through domestic administrative processes to avoid the dispute taking place at all. And another, and of course, there's a lot of these, but just one last one I like to mention is that the most favored nation principle, which is a principle we see in international trade law, WTO law, is also applied commonly in international investment arbitration, which has many complications that I can talk about for hours, but I will save you that boring discussion. But the point is that even if you are entering into arbitration and you are of a national of a country that has no agreement with the country you're getting into an arbitration to, these provisions apply to your dispute as a matter of international legal principle through the most favored nation clause, which obviously can bring a lot of complications to your dispute. So one prime example of international arbitration is international investment treaty arbitration or investment treaty arbitration. And this is my specialty area, and this is obviously this is one of the fastest growing fields in international law practice today. Now, investor state dispute settlement, or ISDS, involves essentially a private company bringing a claim or essentially suing a foreign government, which is quite unique, obviously, because international legal disputes are often reserved for state-to-state disputes. But in ISDS, we have a forum where it allows private sector entities to then engage in legal dispute against the state. Now, how that works is that the basis of an ISDS will take place through what's called international investment agreement. That could be a bilateral investment treaty, a BIT. It can be a FTA, a free trade agreement, or a multilateral trade agreement. It could even include a single provision in a larger document called TIPS, and these are, for example, you can see these commonly in the EU and CARICOM in ASEAN, the former NAFTA, for instance. These will have perhaps one chapter, like Chapter 11 of the former NAFTA, and the USMCA now, that includes Mexico. It'll provide for investment treaty arbitration as a form of dispute settlement for investors. Now, the idea is that if an investment is admitted into the host state, so for example, let's say as a Korean investor, I invest in Mexico, I would then receive protection and rights as an investor in Mexico based on a free trade agreement between Mexico and South Korea. Now, once Mexico admits my investment, permits my investment to take place, my foreign direct investment, I'll be then provided rights and protections the same as a Mexican national in Mexico in terms of protection of my investment. So you can see that this is quite a sprawling phenomenon that has controversies and debates that I'll talk about throughout this presentation. Now, what are the consequences of ISDS? So there are obviously numerous demerits that come with investment arbitration. I cannot go into all of them, but I'll kind of discuss them, at least identify most of them. So as a practitioner, which I guess most of the people in this room are or plan to be, one difficulty of ISDS is that it provides only one window for material submissions. And of course, this changes by forum, but usually you'll have only one window to submit all materials, and it includes evidence, written submissions, and all these things. This means that there's no new submissions that will be considered following the initial submission window. And what does that mean in reality? What that means in reality is that you'll have thousands and thousands of pages being submitted, even documents that have no real or foreseeable relevance to the circumstances of the dispute. Now, as a practitioner, what that means is that you have to be strategic in what kind of materials you're submitting. If you can submit everything that you think might be slightly relevant, but you have to remember that the arbitrators, the tribunal, the people who are judging the dispute are human, and they can only read so many pages per day, and they begin to lose attention, all these things. So it's a matter of strategy about what kind of documents you think will be important and strategic and most effective to that process. And in arbitration, you'll only have one, or depending on the circumstances, one hearing. And that'll give you that gives an opportunity for the practitioner to then highlight what they believe to be important facets of the debate, of the litigation, of the arbitration. But of course, at this point, usually the arbitrator will have already made a decision on what is important and what is not. So that is one very complicated aspect of this forum. Another risk is that investment treaty arbitration is ad hoc, which means that each case is deliberated independently, and it's based only on the circumstances of each individual dispute. What does that mean in reality? In reality, what that means is that no matter how long, how many hundreds of cases of investment disputes there have been in the past, an arbitrator or arbitral tribunal will decide, does not need to respect precedents. They can provide complete independent legal interpretation based on the circumstances of the case, which is quite difficult because as a practitioner, you never know what to expect, even though that, for example, there may be 10 cases all about the same exact subject. They have some sort of pattern in decision making. This may not apply in the arbitration you're engaged in. So this is quite difficult as well. The next consequence is the burden of proof lies on the investor as the claimant party. Now, for technical and complex cases, like this can be very difficult and time consuming. So for instance, if you're trying to argue that a minor change in construction regulation caused the government to then shut down your investment or your project, for example, you'll have to go out of your way and pay for the inspection process to understand, for example, the technical aspects of whether or not your project or your investment did in fact violate those substantive elements of the policy measure, the government measure. And that can be very time consuming, it can be very expensive. And so this is one thing. Also, another aspect is that in construction disputes, it's a little bit easier, but for investment disputes, it's not, because obviously, if you're trying to win the dispute, you're going to try to find the engineer who's going to agree with you. And sometimes that engineer might not provide the best information that can help you, and might actually provide information that can go against your case. So this is a big variable. And lastly, there's a great deal of reputational risk in investment arbitration. So if you are engaged in an ISDS, or even if you are counsel for ISDS, you have to remember that you are essentially going against the government of a different country, right? And that government is many times trying to argue that it's doing something that it's within its rights. Many times, the reputation of not only the investor, which is a company, but also sometimes the attorney and the law firm will suffer some reputational risk, especially when involving, for example, developing economies. Now, very quickly, there are also consequences from the perspective of the host state as well. And one is that the placement of investment law in terms of general international law. Now, if you look at investment law, investment arbitration, there's been a tendency to consider it lex specialis, which is the idea that many aspects of international investment law lie outside the application of general international law. Now, what that means in reality is that it makes it very difficult to predict when and where and how the investment tribunal, arbitration tribunal, will apply general principles of international law in the dispute. So they might not apply any general principles of international law, or they might apply everything according to the threshold of international law in general. And so, but it's impossible again to identify when or how or where this will happen. On a more macro level, another consequence of the state is that obviously by entering into an international investment agreement, it gives up some of its state sovereignty, right? So the government is unable to do whatever it wants if there's a threat of perhaps violating the investor rights. And lastly, if we turn to statistics, there's a great deal of study about sort of who's the winner of investment arbitration. And according to the current data, most of the time, developing countries will have a higher chance of losing investor disputes. And that's obviously very worrying. And one of the main reasons is that, of course, a developing economy who's, for example, engaged in arbitration will not be able to dedicate millions and millions of dollars to pay a top shelf law firm to dedicate 200 lawyers or 100 lawyers to focus on one case, right? Whereas a corporation, for example, like Chevron or Enron, right? These corporations will be able to put in millions of dollars without blinking an eye, and then it'll just be a matter of a constant attack. For example, a company, if they lose an arbitration, investment arbitration, in many cases, since they have entities everywhere, so for example, Chevron in the United States and then Chevron in Britain, they can, if Chevron in America, United States loses a dispute, Chevron in Britain can run the exact same arbitration against, for example, Korea or Mexico from its British entity, right? So this is called parallel proceedings. And this is a major problem in investment arbitration today, and I think arbitration in general. Now, continuing on, well, at the same time, I think at this juncture, it's important to talk about some of the major, some of the main controversies, including involving ISDS. And the first is whether investors should be provided. So, okay, one of the major controversies in ISDS is whether the investors should be provided what's called the minimum standard of treatment, such as full security and protection, whether that should be understood in general law, international law, or if it should be an independent standard. Now, what that means, again, if I go back to the example of me as a Korean investor in Mexico, if, for example, if I create a business in Mexico, and for some reason, I don't know, my business gets literally physically destroyed, right? But the police or the authorities did not engage in due diligence to, for instance, protect my business, right? So in this situation, the idea, I mean, that's an extreme situation, but the idea is whether the investment arbitration, if I continue to that level, will understand full security and protection under the scope of international investment law, independently, or general international law. And currently, I mean, the most common interpretation of this is going to be that international investment law, international investment arbitration is an independent standard. What that means is that investment arbitration is independent from the general principles of international law. And that has largely been connected to what's called the Washington Consensus, which is the idea that there should be more economic integration. There should be more investment. And what that means is that there should be kind of US and sort of North American and European standards of investment protection. But of course, so in that kind of interpretation, a lot of the authority, a lot of the power goes to the investor. But on the opposite side is what's called the Calvo doctrine, and obviously a lot more from there, which is the idea that while the contract and the investment agreement should be respected, there are principles that are above that. And that includes, for example, my permanent sovereignty over natural resources. So even though, for instance, I enter into an investment agreement, and as an investor, I'm protected by the agreement. According to the Calvo doctrine, according to this school of thought, the idea is that the state, so for example, in this situation, Mexico, will always reserve the ability to essentially take back any of the things that I have bought or invested in as a foreign investor based on this a natural law of sovereignty over natural resources. And what that does is that it looks at my investment, even as a foreign investor, as a property, an internal property of a special property of Mexico. So in that situation, even if Mexico, for instance, were to just take all of my assets under this obviously very extreme interpretation of this doctrine, it would mean essentially that I would have no right to compensation. I would have no right in terms of any kinds of forum for the resolution of that dispute or that wrongdoing. So now, sort of examining. So I'm struggling here to kind of discuss this very complicated debate within a very short period of time. But I hope that you're able to kind of understand the main idea behind this conflict. And of course, we can, talk about this later in the Q&A, but I will just talk about this a little bit further. Now, the most important, in my opinion, dispute, or the most important controversy in international investment law is essentially balancing between two sometimes conflicting objectives, right? The first is creating a regulatory environment that is conducive to investment, right? So an environment of laws and regulation and policies that encourage investors to invest more in a country. So if you look at, am I running out of time? No, I'm okay. How much time? Okay, sorry. So a country facing many investment disputes, for example, will often mean that there's some kind of a factor, some kind of a constraint in their legal system that is causing a lack of stability and a lack of predictability that causes investors to resort to arbitration to seek compensation for some kind of wrongdoing. But at the same time, you have to remember that foreign direct investment, FDI, is inherently risky, right? There are an unlimited number of things that can happen to an investor in a foreign country. So as a Korean, for example, can invest in Mexico, but there's an unlimited number of things that can happen to my investment that I can never foresee. And so there's an inherent risk. And the current pandemic we're experiencing now is obviously a testament to this kind of risk that we cannot foresee. Now, the second objective that in terms of balancing, so the first side of the balance is creating favorable conditions for investment, but at the same time, the other side of the balance is that you have to make sure that if you are a government, you have to make sure that the investment that's coming into your country is profitable for you, right? It has to be profitable for the host state or the hosting the investment. So if the state hosting the investment, so in our example, Mexico, is taking all the burden and all the risk and all the cost, right? The question is that, well, what's the point of that investment? It's no longer beneficial and valuable for the host state. And so that becomes the question. But however, more interesting is the non-pecuniary benefits. Essentially the benefits of that are not essentially resulting in some kind of return. And so, for example, if Mexico, or any host, if a state accepts a foreign direct investment, but let's say it has devastating impacts on the local environment, it destroys the forest and poisons the water, right? The question is, well, was that really an investment that's worth it? Did the country really benefit from that investment, right? So the United Nations, in its Sustainable Development Goals, that we're looking at now, the United Nations calls for countries to prioritize what are called productive investments, right? Which are investments that have a clear added value to the host state, not only in terms of monetary value, but also in terms of societal and environmental values. And so it's a matter of not only accepting or admitting investments that may turn out to be profitable in some way, but also including investments that will not damage the environment or will respect local laws or national laws on labor and such things as this. Now, so we can rewrite the central conflict that I've been talking about into a more common expression used in international investment law, which is balancing investor rights and protections against the state's right to regulate. So if I unpack that statement, so if you create conditions, sort of regulatory conditions, legal conditions that are too favorable, that are too good to the investor, what that means is that the government, the state, will be severely limited in its ability to regulate and its ability to conduct policy measures to ensure that the investment does not, for example, destroy its environmental conditions or cause great harm to public interest. And if you create conditions that are too favorable for the investment, even in times of emergencies, like we saw in Argentina in 2001, 2002, the financial crisis, you'll see that the state will be greatly limited in its ability to conduct regulatory measures and basic public policy measures without getting into an investment dispute. So, and for example, in Argentina, they had a significant liquidity crisis that required them to reevaluate their currency, but that required a lot of defaulting on debt. What that meant was that a lot of investors lost huge amounts of their investment in terms of asset value. And as a result, even today, you have dozens of cases ongoing against the Argentine government trying to get back money that they've lost almost 2 decades ago. So you can see why this is problematic. So at the same time, so if you look at the other side, however, if the government has too much power, if the government has too much authority over the investment, then the question then becomes, well, who would want to invest then, right? So if the government has the authority to change the policy and laws at any time without any, for example, input from the investor, then the investor can essentially lose all their rights to all their assets or a significant controlling power over their investment at any time, right? Depending on how the contract is and the agreement is written out. So we can see the balance here is that on one side, if you give too many rights to the investor, you have sort of policy risks for the government. But if you give too many rights to the government, then you create conditions that are not attractive enough for the investor. Now, there have been different ways to approach this in investment arbitration. And these are these 2 questions that I've put on the slide here, which is, well, what is the object and purpose of the investment agreement? Right? Is the main objective of the investment agreement or the treaty to attract more investment, or is it to do something else, such as protect forests or environment, right? The second question is then going to ask, what is investment, right? What technically qualifies or legally qualifies as an investment? And these 2 questions are going to be repeated in almost a great deal of disputes and continue to be debated today. They have no real answer. And the reason why is that oftentimes treaty authors will try to create some elbow room or leeway to try to negotiate these things on the instance of a dispute. Now, one approach to answering this question, so there's essentially two kind of ways to answer these questions, right? And these are two sides of a debate that are sort of very conflicting at this point. So one approach to answering these questions above has been to see the primary object and purpose of an investment agreement as promoting investment. And any other objectives such as protecting sustainable development or environment or social conditions is secondary. And so the best way to achieve that purpose, as this argument goes, is to create conditions where the state is unable to affect the investment at all. So essentially create an environment that's completely liberalized, completely privatized, and completely formalized. And this way that the government is unable to affect the investment without it first going through some kind of a dispute settlement forum. The second argument is known as the police power doctrine, or the police powers doctrine. And this defines and this is an attempt to define investment as requiring a significant contribution to the host state. So just a very quick example. I know that I think I have about 10 minutes left. Is that correct? Thank you. So I'm just going to very quickly go through. I just have just two more slides here, so bear with me. In terms of this idea of a contribution to the host state, a very common example is, for example, let's say that a group of Italian companies invests in a super speed or a highway in Morocco. And they construct the highway in Morocco using only Italian materials. They only invite Italian builders. They do not provide any jobs for the Moroccan state. They do not buy anything from Morocco. And all these things happen. The question then becomes, well, what is the contribution of the Italian highway to the Moroccan government? Is it an investment, or did Morocco simply import an Italian highway? If the Moroccan government just imported an Italian highway, the Italians should not receive the rights of the investor, right? So this is a question of whether the Italian investor was able to provide a significant contribution to the host state, in that case, Morocco. And so in order to achieve these ends, in order to try to understand sort of which investments should and receive protection and which investments do actually contribute significantly to the host state, there has been many methods and tests developed over the years to kind of understand and qualify and also quantify the extent to which the performance of the investment was able to contribute to the host state. And so in order to achieve those ends, the argument is that the host state should be able to reserve as much public policy authority as they want, the right to regulate, to make sure that those outcomes take place. So in that case, Morocco, for example, the argument is that Morocco should be able to maintain all policy authority to ensure that the Italian investment, or any investment for that matter, does provide a contribution, a significant contribution to the Moroccan economy, and not just simply the idea of importing or transaction of an Italian highway, right? But of course, this returns to our original balancing question, which is if you provide too many authorities to the host state, then arguably the Italian company probably would not have invested or not have begun the project at all. Now, in closing, in my final slide, I just want to leave you with a question, and that is, well, how do you define what is the public interest? How do you define what is a contribution to the host state, right? How do you approach that legally? And this is one of the most difficult questions facing international investment arbitration today, and it's a question that I'm researching as my main focus. And this question is so serious that it's even threatening the future of investment arbitration. Now, at the ICC, where I worked, is that the biggest concern, and now today, one of the biggest concerns today is the future of investment arbitration. And one of the biggest questions of that is that, well, is it relevant in a changing world? So until now, this idea of contributions to the host state, this public interest, has been through what's called exclusionary screening, or a negative list approach. And what that means is that there's a list of things where the investor, a list of areas or sectors where the investor has to recognize and accept that they will not have, their rights and protections will not take precedence over the right of the government to enact policy measures. So most commonly, that's most of the agreements up till now, called the older generation agreements, look to international trade law, WTO law, for this list. In Article 20, the chapeau of the GATT, and in Article 20, there's a list of areas such as environmental protection, phytosanitary concerns, and a list of areas that the government reserves the right to regulate. In other words, if you're an investor in any of these areas, you have to simply accept the risk that at one time or another, the government will essentially be able to overpower or take precedence or dominate, take precedence over the existing or prevailing agreement that protects your investment. More recently, there have been different approaches to defining the public interest, and that's been, for example, the positive list agreement, a positive list approach. And we see this in newer generation investment agreements, such as that between the European Union and Canada, which has been recently ratified. And this, what these newer generation agreements do is that they make very clear the rights of the government. So, for example, in the European Union and Canada agreement, it very clearly says that the Canadian government and the the EU will be able to reserve its right to regulate on matters of public interest, national security, and so on at any time without essentially conflicting with the investment agreement and precluding, for instance, the idea of arbitration at that juncture. However, of course, the biggest challenge to this puzzle is an idea that I introduced to this session, and I'm going to close with this, is that legitimacy in investment arbitration and arbitration in general is highly circumstantial. So what is legal, what is legitimate, what is right, or what is wrong is depending on every circumstance of every dispute, technically. And that obviously is difficult, not only as a practitioner, but also as a host state, as a government official, for example, is because the circumstances can be interpreted in different ways by different people. So a legitimate public interest or a public policy, for example, protecting the environment in one situation or one circumstance, can be considered to be illegal and illegitimate in a very similar but a different instance. And there's really no means to essentially require an arbitration tribunal to for instance, respect a past decision, right? So what that means is that arbitration has to rely entirely on a tribunal to practice its discretion, its ability to choose based on the circumstances. And this is essentially called the party autonomous approach. Most times, arbitration tribunals will depend on precedents of past investment tribunals, as well as sometimes international trade law, also in cases at the European Court of Justice, also the International Court of Justice. But of course, again, this depends entirely on the decision of the tribunal at the time. So if you're dealing with a very conservative, constitutionalist tribunal member, then we can have a ruling that perhaps pays no respect or no heed to past precedents or to past rulings. And the question here then is that, well, if you deal with a question like sustainable development, right? And we see every day that our climate is changing, the temperatures are rising, and the conditions that we're existing in now are different from the conditions we've existed in last year or 10 years earlier. Then the question becomes, well, if arbitration tribunals are looking at decisions that have been taking place 10 years ago, the question is, well, how relevant are those decisions today? And just in my last minute or so, one very prominent dispute that I won't be able to go into in detail because of time is Philip Morris Asia versus Australia. And in this particular case, what happened was that Australia had introduced plain packaging rules for cigarettes, right? Which meant that, as you can see from the picture here, investors or companies like Marlboro were unable to put their logo onto a cigarette packaging because the idea was that it would promote smoking. And the idea behind the public policy measure, which was to require all cigarette boxes to have the same exact appearance, is that, well, they wanted to try to reduce the amount of smoking in Australia for public health reasons, right? So here you have a very interesting case where the government is trying to say, hey, people need to stop smoking, but if they see, hey, Marlboro Light maybe is less damaging to my health than Marlboro regular, I don't know, medium, then they're going to smoke more cigarettes. And Australia was trying to counter that by using public policy measures, but then Philip Morris had gone to a dispute saying that, hey, we spent all this money designing the logo, creating advertisements in Australia, who's going to compensate for us for all these things that we've done? And so this is a real prime example of some of the consequences of investment arbitration, is that there is obviously no maladas fides, there's no wrongful intention of the government of Australia for trying to do this policy, right? All cigarette companies have the exact same rule. And the idea was that, yes, according to the WHO, some X percentage of people will reduce smoking if this happened. They based it on all this data, but in the end, it didn't matter because Philip Morris was able to run this dispute. Fortunately, the tribunal had ruled in favor of Australia, but at the same time, we have to remember that Australia had to pay $39 million in legal fees, and all that money came out of tax dollars, essentially. Now, and with that, that concludes my presentation, and I thank you for your attention and time.
Thank you very much for your participation, Dr. Lee. Thank you for sharing your experience. It was very interesting, and I mention again, it is an honor to have you in our committee as a speaker. And for the Universidad Autónoma de Querétaro, it's simply priceless to interact with such brilliant professionals. If you want, we can open a space for questions at this moment. I suggest that, the audience, the students can, ask directly, open the microphone, either in English or in Spanish. Si ustedes están de acuerdo, también pueden hacerlo en español. Interactuar, con los expositores. As you can see, there's a very, very important topics. For one side, it's a mediation, international mediation topic addressed by Diana Cuevas, and on the other hand, investment arbitration in general terms, addressed by Dr. Lee. But of course, you can either ask about his professional development in the UN, if you want. Please, someone want to ask? Anyone? Any questions? ¿Alguna pregunta del auditorio? La pueden hacer en español también, no hay problema, o en inglés. Bueno, yo tengo, I have a question for Diana. Diana, you spoke about the Singapore Convention as, I don't know if the audience knows that Mexico did not sign the Singapore Convention. Do you think there's any advantage for Mexico to sign this important convention? What kind of benefits do the convention can bring to Mexico, especially when we are trying to encourage a new law in alternative dispute resolution, including mediation. What do you think about that?
Well, I think it's a very interesting and very good question for this time being. One can arise the question of sovereignty, whether we want to sign the convention or not. However, if we want to harmonize the law and make sure that our settlements are treated in an equal way and enforced in another nation, it would be important to consider signing the convention. It wouldn't affect us in the way that, as I said, we can opt out. We can be signatories of the convention and we can actually ratify the convention. However, at the time that we settle an agreement and we write the settlement, we can opt out to not utilizing the requirements of the Singapore Convention. In other words, we can have it both ways. We can be part of the convention, and in individual settlements, if we write the clause that we opt out of applying the convention for that settlement per se, we can do so. So, finally, I think the conclusion is it would be advantageous for us to harmonize with the rest of the world.
Thank you very much, Diana. For Dr. Lee, you address important topic in terms of investment arbitration. In Mexico, we are very familiar with Mexican arbitration centers, of course, and with the ICC, in terms of institutional arbitration. But we don't know a lot about the arbitration centers in Asia. Do you think, is there enough strong support of rules for arbitration in Asian arbitration center? Do you think they are reliable to be part of arbitration clause and conduct an arbitration proceeding, based on the arbitration rules in Asia?
Yeah, thank you for your question. And I think it goes back to, I think, what Diana said about, and she mentioned sort of this idea of language questions and things like this. But I mean, most likely in a case where, for example, an Asian investor enters into a dispute with Mexico, the dispute probably will not go to Mexico or Asia. It'll most likely go to London or Washington, where you have more established centers, or maybe Singapore, for instance. And unfortunately, there's been this kind of a game of who can provide the best arbitration center, and a lot of times the rules are overlapping. They're not very different. They rely on the same set of rules, but ultimately the question becomes, for example, in China, if you enter into a dispute in China on any, for example, investment involving a Chinese corporation, many times they might stipulate that the dispute will have to go through the Shanghai International Arbitration Center, the SIAC. And in those situations, it's a matter of how you draft the contract. Essentially, if there's an investment between China and Mexico, if a Chinese company in Mexico or a Mexican company in China, it'll have to be depending entirely on not on manpower or who is able to do it. It's about the rules that are applying. And if those rules don't apply, for example, if there's no condition that says you have to have this arbitration, the seat of arbitration must be in Shanghai or whatever, it'll most likely go to somewhere where there's the most predictability in how the arbitration will be conducted, and that will most likely be either in the London Court of International Arbitration or more frequently the World Bank ICSID, depending on the country. Yeah.
Thank you very much, and I have another question for you. as you know, Universidad Autónoma de Querétaro is one of the most important universities in Mexico. And based of the profile of this bachelor, I mean the students of the Bachelor of International Trade and International Affairs that are, you know, attending this conference. What do you, I mean, what kind of advice can you give to the students to be involved in, you know, in the UN and the activities that that has the UN, because they are very, you know, interested in participating in this kind of international organizations, you know, according to the profile that they have in this bachelor. What do you think about that?
I think that there are many opportunities for Mexican students or students of Mexican nationality to engage in these opportunities. But I think perhaps the journey will begin in law school. So even the earliest forms of engagement with the United Nations will be as an intern. And interns require, you have to be part of a graduate school program. And unfortunately, the rules of the International Commission for Civil Service does not permit the United Nations to pay interns. So this is a great financial burden. But even after that, there are many ways to engage in the United Nations, such as the Young Professionals Program, the YPP, where I believe Mexico is almost every year part of that. Also, if there are, I know that there are, I've met Mexican colleagues who have gone through the JPO, the Junior Professional Program, which is basically funded through the Mexican government for a Mexican practitioner, not only of law, but for really any field, to have a 2-year non-renewable contract with the United Nations to work on that. And that's also a very good opportunity. Myself, I've gone through the Young Professionals Program as well. So I began early. I spent quite a long time.
You look very young, Dr. Lee.
It's my, I think it's the poor quality of my camera that is shading my age. It's covering my age entirely. I've developed a system where I look very young, but.
If we see your resume, it's very, you have a very, very strong experience, you know, and apparently you have you know, maybe 70 years, but you are very, very young based on the strong experience that you have.
No, I mean, but I mean, I think a lot of times, unfortunately, I think I mean, the competition is very obviously very strong to get into any of these programs. But if I think the best advice I give to my students or anyone and who asked me about this is that, you know, if you apply and you don't get in, don't get discouraged. I mean, Kofi Annan, who is my hero and the reason why I joined the institution, he said you can take the man out of the UN, but you cannot take the UN out of the man. And what that means is that you have to essentially, and that's not very, this is very gender specific and unfortunate, but essentially, I think the best advice I can give to any student is that if you really believe in the mandate of the United Nations and its honorable mission, then I think that as long as you keep trying, even though it might be hard to get in at first, once you get your foot into the door, it becomes much easier to continue your career as a civil servant. And I think more important than getting into the United Nations is staying in the United Nations, because it's not an easy institution to work for in terms of the bureaucracy, but at the same time, it's worth it because you're serving a public good and a public interest that I think is worth the ambition and the effort to do so.
Thank you very much, Dr. Lee. Anyone who want to participate or to ask a question from audience?
Doctor, thank you very much. I have a question. Does the university have a virtual library for international students to get some material?
I don't, in terms of, do you mean the library at the UN or the library at Lund?
Yeah, library at Lund. Yeah, virtual library in order to get some material to download for students, international
yes.
students.
I don't know how much of it is public access, but there are systems that also, I know that if you have any materials, specific materials, you can email the law library at Lund. And if it doesn't infringe on any copyright agreements, then I believe that they can provide materials to your students as long as it's within reason. But again, I think you have to check this. We'd have to check with the library, and I can do this as well.
Okay, thank you very much.
Okay, thank you again, Dr. Lee. Thank you again, Diana Cuevas. Just for closing, this conference, I'd like to give the voice to our Vice President of this committee, Samuel Villazón, just to close and to get some remarks or conclusion and to explain the following activities that our committee has in the future. Please, Samuel, you have the voice.
Thank you, Mr. President. Well, as a matter of conclusion, I'm going to share with you 4 reasons why you should consider mediation. Mediation, the first one is mediation takes significantly less time than arbitration or litigation and involves much lower costs. The second one is mediation process enables the parties to reach agreement on solution which could not achieve through an adjudicative process such as arbitration or litigation, and which would not therefore be available through the rendering of an arbitral award or a court decision. For example, the parties' preferred solution to a contractual dispute may be to renegotiate the terms of a contract. The renegotiation of a contract is possible in mediation, whereas there is unlikely to be any legal basis for seeking such relief in arbitration or litigation. Third is, while the adjudicative process focuses on the parties' legal rights, mediation helps parties also to take into consideration commercial and other interests. This is an important difference between mediation and arbitration or litigation. The mediation process can help parties acquire a better understanding of each other's needs and interests so they can look for a solution which accommodates these needs and interests as far as possible. And fourth, mediation can be a particularly useful tool when the parties in dispute have an ongoing relationship, such as a joint venture or long-term supply contract. Mediation is likely to be less disruptive to that relationship than litigation or arbitration. So that concludes our today's conference. Hoping you enjoyed it as much as we did. We thank you to the audience for your time, and of course, thank you to our presenters for your valuable insight. Thank you very much. De igual forma, agradecemos a la Universidad Autónoma de Querétaro, de forma específica a la licenciada, a la maestra Mónica, quien nos ha abierto la puerta al comité de arbitraje cada ocasión que lo hemos, hemos tocado la puerta, y cada vez que ella nos ha buscado, hemos encontrado una casa a la licenciatura en Negocios y Comercio Internacional. Muchísimas gracias. Nuestros siguientes eventos para el Comité de Arbitraje Bajío es nuestra sesión, que será el 9 de octubre. Hablaremos, estamos por confirmar el tema, pero evidentemente les participaremos, y tendremos algunas otras conferencias de apertura de clases, que también esta es una gran ventaja que nos permite el Zoom, tener conferencias internacionales, como fue el caso del doctor Lee, a quien agradecemos. Muchísimas gracias a la universidad, muchísimas gracias a todos los participantes, a la maestra Mónica López Arellano, a la licenciatura en Negocios y Comercio Internacional, a la Universidad Autónoma de Querétaro. Gracias por su participación.
Muchas gracias, Samuel. Muchas gracias de nuevo a todos los estudiantes. Thank you, Mr. Dr. Lee for being here, and Diana Cuevas for sharing, you know, their experience in this field. And see you soon. Thank you very much. Gracias a todos.
Gracias. Hasta luego.
Thank you.